Hi, I'm Domenic Romano at Romano Law. Today I'll be discussing the statute of limitations in employment law claims. As an employer or employee, it's important to be familiar with labor laws and how they affect you and your company. There are four main types of employment law claims: discrimination and sexual harassment, age discrimination, wage and hour violations, and wrongful termination. Now, let's say you worked for a company in New York State a few years ago, and you think, they might have violated some employment laws. But it's been a while since you left the job, and you're not sure if you still have any legal recourse. Do you? Well, the short answer is it depends on the statute of limitations for the specific employment law violation that may have occurred. In New York State, for example, statutes of limitations determine the time limits for filing a lawsuit or a claim for a particular legal issue. Now, these vary depending on the type of violation. For example, claims under Title VII of the Federal Civil Rights Act of 1964, which prohibit discrimination based on race, color, religion, sex, or national origin, must be filed with the Equal Employment Opportunity Commission, or the EEOC, within 300 days of the alleged discriminatory act. Now, that might seem like a long time, but it's not, because it takes time to prepare evidence and to present it to the EEOC. That's why it's important to act quickly if you suspect discrimination in the workplace, or if you are an employer and have been accused of such action. There are also state and local laws that prohibit discrimination based on other characteristics, such as age, sexual orientation, or disability. The statute of limitations for these other claims can vary, typically between 3 to 6 years, depending on the specific law and the state. Now, another common type of employment law violation is wage and hour. Claims under the Federal Fair Labor Standards Act set minimum wage and overtime standards, but they must be filed within 2 years of the violation, or 3 years if the alleged harm was willful, meaning it was done intentionally. The employer knew about the rules and then didn't follow them. New York State has its wage and hour laws, which have a 6-year statute of limitations, so it's a little more generous timeline in New York. The next type of main employment law violation is wrongful termination, or wrongful firing. These must be filed in New York State within 3 years of the termination, but there are some exceptions and nuances. That's why it's always a good idea to consult with an experienced employment lawyer in your jurisdiction that can help you navigate the legal system. Please note that generally these statute of limitations vary on the type of claim and where the claim is brought, including sometimes the city it's brought in. If you believe that you've been a victim of adverse employment action or have an employee or former employee claiming that your company has violated their employment rights, consult with an experienced attorney.